Hello, and welcome to the webinar presented in collaboration with the Connecticut, New York, Pennsylvania, Virginia, and West Virginia MGMAs. We would like to thank today's webinar sponsor, the West Virginia MGMA. My name is Erin, and I will be your host. Before we begin, I'd like to review a few housekeeping items and let you know how to participate. The presentation is on the left of your screen, while the chat and Q&A window is on the right. The audio information is in the upper right corner of your screen. By default, you're listening to the webinar using your computer speakers. You may use your phone to listen to the webinar by selecting the Use Telephone button under the audio drop-down box. The dial-in ID number and passcode dial-in information will be displayed there. In order to make the most of our time today, our presenters have asked that you send any questions through the chat or Q&A boxes. I will do my best to make sure that all your questions get addressed to our presenters. We will respond to as many questions as possible throughout the presentation. The chat feature can also be used for any technical issues you may encounter. I'll resolve your issues as best as possible. As a reminder, we're recording today's webinar. You can view the recording on participating MGMA websites early next week. Today's presentation is led by Robert Lyles and Paul Weidenfeld. I'm going to let them take it from here and they will introduce themselves. Thanks, Robert and Paul.
Thank you very much. Glad to be here. Appreciate the opportunity to do this presentation for MGMA. I'm here with my law partner, Paul Weidenfeld. Just very briefly, I'll give you my background, and then Paul can kind of talk about his background over at exclusion screening. Paul wears many hats. He is a healthcare defense attorney, and he is also the chief legal counsel over at exclusion screening. My background, I've been in healthcare for a long time. Started out in healthcare management, have a master's in hospital administration, worked in hospitals, then went to law school. Out of law school, I was hired as a federal prosecutor, an assistant U.S. attorney. Worked as an assistant U.S. attorney in the Southern District of Texas, and then they passed HIPAA. And in '96, when they passed HIPAA, they wanted someone with a healthcare background, so they detailed me to Washington, and I was the nation's first healthcare fraud coordinator for all the U.S. attorney's offices in the country. Did that for a number of years, and then went into private practice, and now I represent the wrongfully accused around the country. My law partner and my co-presenter here on the phone is Paul Weidenfeld. And I know Paul from our DOJ days. Paul, can you kind of give us a thumbnail sketch of your background and what you're doing at exclusion screening?
Sure, absolutely, Robert. So, as Robert said, my name is Paul Weidenfeld, and in many ways we have some similar backgrounds, Robert and I, but slightly different. So I spent the first 15 years of my legal career doing many things, but mostly litigation. I was a trial lawyer and went to the U.S. Attorney's Office after 15 years or so, and was fortunate enough to get into the healthcare fraud, to become the coordinator for the healthcare fraud responsibilities. And that I took that position in 1996, which coincidentally, as Robert says, was the year that HIPAA was passed, and that was the beginning of my healthcare fraud focus. And from 1996 until then, I've been almost completely focused on healthcare fraud. I worked in the government, worked for Department of Justice, handled a number of matters, followed Robert's footsteps as the Department of Justice healthcare fraud coordinator. Not directly followed. I think I was the third or fourth one. And in that position, we would both be the liaison for all of the enforcement entities that were involved in healthcare fraud. So it gives us this broad spectrum. So we would be sitting in the meetings with Health and Human Services, with OIG. We would be in the meetings with all the different agencies. And so we did that, and I did that, and then since I left Department of Justice, I've been doing healthcare fraud, representing providers and so forth. And about a half a dozen years ago or so, I started as a co-founder of Exclusion Screening. And that is a company that provides screening service, but specifically we screen for excluded entities, individuals, and entities pursuant to the requirements of the Office of the Inspector General. And we focused on that because frankly, because we represented providers who had that issue, and it kind of seemed like that was needed. So that's what I've been doing, and I hand it back to you, Robert.
Great, great. So one of the things we want to talk about today is we really are looking at government prosecutions, and we're looking, frankly, at the folks that are on this presentation. Are you a target? Are you a subject of an investigation? If your docs get in trouble, what's the likelihood that they're going to also be looking at you? Because that's what we're seeing these days, frankly. And kind of before we get into that part of the presentation, I mean, there are a couple quotes that I just love. And these kind of encapsulate your obligations as a practice administrator, as an office manager, or as a physician in a practice. The first one, of course, going back to 1920, men must turn square corners when they deal with the government. Now, to me, what that means is the government may have some screwy rules, and a lot of the rules that they have may be difficult to understand and even more difficult to implement. But the fact is, if you're going to do business with the government, you have to follow their rules. And that is so important because many times, as we find, their rules regarding medical necessity don't make any sense. They're really arguing about coverage issues, not medical necessity issues. Their rules regarding documentation are so
onerous, maybe.
Yes, that if you fail to have a signed order, for instance, even though the doctor actually did the review and ordered certain services or tests or supplies, they won't pay it.
And we know, Robert, we know that people can't be perfect, and nobody is perfect except, of course, a federal judge. They think they are perfect, but other than them, nobody thinks they're perfect. So the key is, and we talk about this later in the program, about the compliance and how important it is to do that as much as possible, so that you may not do it all, and there are some really onerous, crazy, difficult requirements that you just shake your head at. But the more that you do them, and the more that it becomes part of your process, then the less likely you are to have issues with respect to a failure to do it, because it's going to happen.
It is going to happen. So let's talk about where we are today. Well, one of the things to kind of keep in mind, well, that's incorrect there. That 2018, it should be 2019. But the numbers, though, are still correct. Last year, the government brought in over $3 billion under the False Claims Act. And of that $3 billion, $2.6 billion was involved in healthcare. So even though the overall number in terms of raw collections under the False Claims Act slightly went down, the number related to healthcare actually went up from the previous year.
And those numbers, those healthcare numbers, I've looked at them, Robert and I have looked at them pretty carefully over the years, and they are very consistently between $2 and $3 billion every year. And you get, and actually in many years it's right at 2.4 and it doesn't change. And so the question is, the point of that, or an important point to note, is that there used to be, and it wasn't unusual to see these really large settlements. And, I was involved in the Tenant case, which was a $900 million settlement, for instance. And that gets you pretty close to 2.4 billion really fast.
It does.
Well, those bigger cases, most healthcare providers are getting smarter. And a lot of those big cases were drug companies, and they've changed a lot of their practices. So if they're still getting that 2.4 billion or 2.6 as they did last year, they're getting it from not so many of those big sources. They've got to find other places to go. And my point is, where do you think they're going to go? They're just going to have to go down until they reach you.
They're getting more and more smaller cases with smaller recoveries, but collectively it's still adding up to the same amount.
And that the problem is that puts the focus on, that increases that focus on who they're going to go after, and it makes more people targets, or at least potential targets than they, there are cases, and Robert will tell you, right, where you are over in Houston, if a case wasn't worth $1 million when I was there, they weren't even interested. They wouldn't even talk to you.
Right.
Right. Now,
Right now, I've got cases that they're pursuing in Texas for less than $20,000 of alleged kickbacks, and I do mean alleged because I don't believe that they are kickbacks. And the government's still hot to trot to pursue it.
I had an overpayment case that was really explicable and not their fault, but it was only about $100,000 or so, and they pursued that like a dog with a bone, man.
Yep.
I tell you.
Now,
So-
one of the other numbers I want to point out is during this period that we're talking about, where they brought in $2.6 billion under the False Claims Act. The False Claims Act, of course, I mean, primarily those cases, there were 633 whistleblower cases, and those represent, believe it or not, what percentage of the overall number of cases filed, Paul?
Oh, it's those whistleblower cases of False Claims Act cases they pursue. They're like over 90%, well over 90%.
So think about this for a second, guys. The 633 cases, if that's 90% of the False Claims Act cases, this is truly the proverbial tail wagging the dog. Okay, the Department of Justice is not really driving the train when it comes to healthcare fraud enforcement and investigation under the False Claims Act. The fact is, the whistleblowers, the recovery, the relators they're really the ones that are really setting out the agenda for the government.
And that's such an important point that you make, Robert, because it's not that we malign whistleblowers. You've often said that you've rarely come across one that wasn't well purposed, that hadn't brought it up in meetings or some other reason. But the fact of the matter is, whatever their reason is and however it comes, the fact is that you're right that the agenda is driven internally by an office, because that's where they put their resources, because it's over 90% of the cases and over 95% of the recoveries.
Mm-hmm.
So so the cases are coming internally, and they're coming internally by who, Robert? Who brings it?
By the whistleblowers, by your staff.
Wow.
Okay, one of the things that we're not going to spend a lot of time on it, but one of the big changes under the Affordable Care Act, of course, is they said that if you have an overpayment and you fail to report and return the monies within 60 days, and we're not going to get into the whole 6-month extension issue, to figure out the scope that CMS has issued in the Federal Register. But the fact is, you have 60 days to report and return those monies. And if you don't, then that mere overpayment turns into a violation, potentially, of the Civil False Claims Act. Okay. So what that means is literally anyone in your organization is a potential whistleblower, which is, of course, why you have to have an effective compliance plan in place, why you have to train your staff and let them know they have an affirmative obligation to bring problems to your attention so you can fix them.
Absolutely. And a corollary to that is something else we're not going to discuss very much, but which is worthy of note. And that is that, one of the best ways, or one of the most important ways of getting that information is through a hotline, and the ability for people to anonymously, because that's where most hotlines come, because they're concerned. Whistleblowers typically are often, not typically, but often concerned about their own job status. And so the availability of an anonymous reporting system is very important, because they'll tell you things. The sooner you find out about something, the quicker you can handle it. The quicker you can handle it, the less expensive it is in the long run. And it may not even have been a problem. It may have been they were just wrong. And you can identify it, and you can fix it, because there's really no fix. The fix may well be an explanation that makes sense to the person who just failed to understand it, but thinks something's a problem.
And if you don't have that hotline, I mean, just as one example, setting aside all the state hotlines that are out there, the OIG Medicare fraud hotline last year received over 120,000 calls.
And they followed up. I don't remember what the statistics. I don't know if you remember them, but they actually follow up in open cases. A very large, a surprisingly large percentage of those cases. They really look at those tips.
And the point is, if you don't have this pressure valve or some way for them to share their concerns with you, they're still going to go somewhere. They're going to go straight to the government. And then you may not have a chance to remedy the problem.
Or that remedy may be very expensive.
Now, what about these exclusion actions, Paul? I mean, it says last year that OIG, now this is not talking about the states, just OIG excluded 2,600 individuals and entities. Why does that matter?
Well, so that's important too, because they really focus. If you look at their whenever press releases at the end of every year, every quarter, whatever, they always talk about how many people that they have excluded, an excluded individual. And so this is, I mean, well, as you see, I am part of exclusion screening stuff. So, but we did this because an excluded individual cannot participate directly or indirectly in any claim that goes to either a state or Medicare or Medicaid, any government program. Now, an OIG exclusion is worthy of a state exclusion, and most states pick them up, but they cannot participate in. When they say directly or indirectly, the OIG guidance that was issued in 2013 extends that to even volunteers.
They're paid nothing.
Just a pure volunteer who participates, who does a service that's within a bundle of a reimbursement bundle. An example of that would be any volunteer at a nursing home, because the chances are that volunteer is doing something that is actually required, right? I mean, if whatever they're doing, if they're involved in any activity. So even if, so you really need to make sure from a legal perspective, and by the way, every state, every Medicaid program has essentially the same rules. All the Advantage plans and the Part D, they have the same rules, and the privates mostly have that requirement. Now, why is that? You get excluded because you've been either convicted of a healthcare fraud, or convicted of some other type of fraud, or that you've had patient abuse, or drug-related offenses, enumerated drug-related offenses. In other words, now there are other reasons, and we're not going to go through the whole thing. And some people get excluded for things that may seem not so bad, like not paying government loans, like that can get you excluded. But most of the time, that's the rare example. Most of the time, what do you think? If it's drugs, if it's patient abuse, if it's healthcare fraud, do you think that person really is going to be a benefit to your organization? That they're going to provide good services, that they're going to be good in the office, that they're going to be helpful, or that they're, as a practical matter, the OIG has decided that as a matter of law, these people pose a risk to patients and a risk to your funding. But as a practical matter, every risk that you have involves your people, and these are just people that you can't have on your side.
That's right. That's right. Okay. So let's, one of the things that is important. I mean, we've talked a little bit about the current enforcement environment, but we also think it's important to kind of point out, why does this matter to you? If you're an office manager, if you are the practice administrator or the CEO of a clinic, well, it matters because DOJ these days has made it very clear that they're not just going after corporations anymore. I mean, the fact of the matter is a corporation is a fictitious person. And what we've seen in the past, of course, especially with the bank fraud cases, for instance, that handled at the very end of Bush 2 and the very beginning of the Obama administration, when we had to bail out all the banks for all the misconduct that they were involved in, you probably can't name a single person, an individual who was prosecuted. Well, those days are over. And as we're going to see from some of the examples that are out there now, DOJ now takes a position that you folks that are on this call, whether you're an office administrator, a practice manager, a biller, or a coder, you are involved in the billing and coding of services to Medicare, Medicaid, private payers, and the rest of it. And as such, since you're part of this overall system, you have to be held accountable if, in fact, it turns out that you're wrongfully billing for services that were either rendered incorrectly, not rendered at all, or not medically necessary, and the rest of it.
And it wasn't long ago that Sally Yates, who was then acting Attorney General, issued a memo, which is still good law, which says that, if you that you can't just go for try and get money from a corporation and call it a day, that you need to focus on the individuals, because they are the ones that are committing the act. I mean, if we get it is kind of outrageous in many ways if you're gonna settle a case for $100 million or $50 million or any amount, and so that sounds like a lot of bad conduct where it costs a lot of money and nothing happens to anybody. They just write a check and then they write it off. Often they've changed the rules recently that makes it much more difficult to write it off, but that's just in the last couple of years. Before that was it. They'd write it off and then they would, they'd write it off of their taxes. So she says, wait a minute, it's time to, also look at who did it and make them accountable as well. Because you can't put a corporation in jail, but you can a person, and you should if they're the ones that are really doing it.
Paul, I think it's especially notable too. I mean, Sally Yates, for the folks that are participating in this webinar, you may recall she was the Deputy Attorney General under the Obama administration, and then when she wrote the Yates memo, which has now been incorporated into the Justice Manual and tweaked here and there, but still the concepts are still in place. And then she was the acting Attorney General who was fired by President Trump. Now, why is this so important? Well, it's important because, love him or leave him, President Trump has gone through and slashed regulations across the board when it comes to agencies. And they have been especially harsh on executive orders and other guidance that was issued during the previous administration. Interestingly, though, they did not touch the Yates memo. So even though he fired her when she was acting Attorney General, he still kept this guidance in place. And this is really important because, as Paul says, it really kind of puts things into perspective. Corporations can't violate the law. Individuals violate the law. And frankly, doctors have a hard time doing it by themselves. They do it in conjunction with the actions of their office managers, their billers, and their coders. Now, you may disagree with that, but that's what the prosecutions are doing these days. When they go in there, they're not just looking at the doctors anymore like they used to. As recently as, 6 or 7 years ago, it was pretty unusual to see them go after an office manager. If you actually go back and look at all the press releases. Now, when they're going after the doctors, it's very common to see that they've gone after the office manager and also the biller.
So, Robert, what are some of the primary risks? You've got up here the kickback statute. That's a big deal these days, huh?
It is a big deal, especially on the home health and hospice side. And for anyone that's participating in this call, if you work for a DME company or a lab, or you happen to work for any kind of pain management clinic,
if you have marketing,
that's right,
external marketing.
So important. You got to understand market. It's really what it comes down to. Looking at your business relationships. How do you get your business? Where do you send referrals to? That's where the government goes every time in these cases. And keep in mind that business practices, marketing practices that are perfectly legal in any other industry in this country are likely illegal in healthcare.
That's absolutely right. It's just, they've created this universe that the universe of healthcare law that we all live in is a thing unto itself. It's sui generis, as I think the Latin, not the only Latin expression I know, but it's just, and so if you come from another area and you do things that are absolutely normal are not, and they focus on kickbacks, and this is relevant, not completely new, but relatively new. And the reason I like to focus on kickbacks is because they're so tangible in the sense that, someone gave someone something and they think you got something in return. And here's the thing about kickbacks. You can't give if you give anything, what they call remuneration, if you give anything and
anything of value.
Anything of value. And anything you give somebody, they're going to interpret as value, right, Robert?
That's right.
Just about. So if you give them something of value and you get business back in return, in the real world, that doesn't, you're not giving it to get that back. It may be appreciation, it may be whatever. There is an assumption, and they will absolutely think that and if A happened and B happened, then A caused B. If I gave you something and I got business from you, that government is going to assume that was in return for business. And it's easily proved because two things go back and forth. And so that's how you have to be. That's why you have to really be aware of things. And instance, as Robert says, home health, because that's the easiest example. The easiest example being a the chief medical officer of the healthcare, the home health agency, right? You have to give him, you pay him for that service, but he's got to identify everything he did that earned that money. Otherwise, they're going to assume it was given to him for only one reason, and that's to send you business.
That's right. It's important to kind of note also that there have been increases in both the penalties and the length of imprisonment under the anti-kickback statute. It's gone up from $25,000 to $100,000, and from 5 years to 10 years.
Yeah, and the intent, Robert, they've moved the intent bar too, haven't they?
Well, they did. Under the Affordable Care Act, they really kind of watered it down. It still has a knowingly and willfully element, but you no longer have to have actual knowledge or specific intent, essentially, to violate the statute. Now, what does that mean? Great question.
You don't have to know it's a healthcare fraud. You just have to know you're doing something wrong. That's kind of a weird, or that you're doing this. Anyway, so
yeah, it's very tough, and I have a real problem with the new interpretation, or how they currently interpret violations. False Claims Act. We've talked about the False Claims Act already, in the sense that this is the 800-pound gorilla on the civil side. If you knowingly submit or cause to be submitted a false claim to the government, it can be a false claim, a violation of the statute. Knowingly is not just actual knowledge, it's also reckless disregard or deliberate ignorance.
Think ostrich head in the sand. Think someone coming to you and trying to tell you, wait, you're breaking the rules, and you've got your hands over your ears and you're going la 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 la. That
exactly.
Those two things.
So the False Claims Act is very broadly written. The vast majority of all those cases settle if they end up going forward at all. And part of the reason for that, of course, is, first of all, the statute of limitations under the False Claims Act is long. I mean, most criminal statutes have a statute of limitations of 5 years, unless it's a continuing fraud. Under the False Claims Act, it's 6 years, or 3 years after the government learns about it, up to a maximum of 10 years. So the government can go back as far as 10 years. So if you were doing something wrong in terms of your use of modifiers, or billing under somebody's number that you shouldn't have, or billing it under the wrong place of service code, whatever it is, they can go back a long ways. And the penalties go up every year. And they're keyed to the inflation index. It's currently $11,665 to $23,000 per false claim. That's exactly right. Per false claim.
Ridiculous.
Now, Paul, we talked about the federal anti-kickback statute. We've talked about the federal Civil False Claims Act. But what is ECRA?
ECRA is the Eliminating Kickbacks and Recovery Act, which is part of and it's there on the slide. I mean, this is ridiculous, right? The support used to sort of prevent that promotes an opioid recovery and treatment for patients and communities act.
Right.
Silly as that.
And essentially, ECRA was I mean, first of all, they limited it, okay, to only three little silos of organizations: recovery homes, clinical treatment facilities, and the labs. The problem is there was no connection, no requirement that the lab category has to be limited to recovery homes and clinical treatment facilities.
So what are they trying to do? What was the deal with these things?
Well, what they're really trying to do, Paul, is they're trying to get rid of kickbacks on the private payer side.
And specifically, and they're doing it with respect to these areas because there is a concern, right, that in those particular areas, there was a lot of people paying in order to get the labs. You can explain it better than I can, to be honest.
Well, unfortunately, there were a lot of examples where they had found sober homes and addiction treatment centers to have engaged in wrongful business relationships with labs. And since they were billing private payers, not Medicare or Medicaid, a lot of times it was kind of falling through the cracks. And some of these folks would actually go out of their way, and they would have these carve out agreements where, they would only send over, under these business agreements, they would only send over private payer type claims. Now, the problem is this: most states, it's already against the law to engage in kickback activity involving private payer claims. There are state all payer statutes that really kind of cover that. Okay. The problem we run across, though, is the states were not enforcing these statutes. They didn't have the manpower. They didn't have the investigative wherewithal to go out and really spend time to do the bidding, as they saw it, of these private insurance companies. Okay. So one of the things that, and I'm sure I don't know who the lobbyists were, but I'm sure they were very involved in this. The lobbyists for the private payers went in and said, hey, we need a federal statute so that we can really kind of raise this a lot easier to the federal level so that kickbacks on the private payer side can be more easily prosecuted by the federal government.
So now the thing about this is you may be, if you're listening, you may be saying, well, I don't deal with this. I don't deal with this. This was mainly for the opioid crisis and sober homes and that kind of thing. It has nothing to do with me. Well, here's the thing. When they added labs, it made it something that counts with you because everybody deals with not everybody, but almost all providers are dealing with labs in one way or another. Some more, some a lot more, some a ton. And a lot of times the labs have had agreements with, and they were only dealing in, even if it was all private pay. So they would have these agreements where the lab may be doing a lot of work in the office, which is pretty much prohibited. And they would provide a lot of services and get a lot of referrals. It was prohibited and enforced on the federal side, but that sort of thing wasn't. But now everybody deals with labs. And so all of your relationships with labs are now under the microscope. And you really need to look at whether you're getting things, what that relationship is, because you are dealing with labs. I'm almost all of you.
Got to be careful, no question. All right, so let's talk about some of the cases here that we've seen. And understand these are just examples. This is not exhaustive by any means. Okay. And in this particular case in Massachusetts that just came out in January, they went after the two dentists who were engaging in wrongdoing, but they also went after the practice office manager. Now, the interesting thing about this case is there was a dentist who had been excluded from participation. So in other words, he could not bill for Medicare, Medicaid, or other federal health benefit program patients. He just couldn't do it. So apparently what was happening was this practice brought him in, had him provide dental services, and then they billed him under the number of the non-excluded dentist. Okay. Now, the interesting thing about it is they didn't just go after the two dentists that were engaging in wrongdoing. I mean, you have to understand prosecutors look at this and they see, well, this is kind of a higher level of wrongdoing because you actually had to engage in subterfuge to kind of falsify who is providing the services. They also went after the practice office manager because they said there's no way these services could have been improperly billed without buy-in and involvement of the office manager.
So the one of the thing is that with excluded individuals, they may have a license. Just because you have a license, it doesn't mean that you're not excluded. We see that all the time. For instance, someone may get excluded for a long period of time. They may lose their license, but then they go through the licensing board and they get it back, but they may still be excluded. And so there's this tendency, well, we should be able to bill his services. We should be able to, do something because he's got his license. Well, maybe not. And there's a lot of instances where people who are, have lost their license and they can't bill or they've been excluded, they try and get back in an indirect way. And that's, I think, the point of that case. You can't come back, you obviously can't come back indirectly. This Louisiana case is interesting to me because, well, I was an assistant U.S. attorney in New Orleans for 10 or 12 or however many years before I became the healthcare fraud coordinator. And so, in Louisiana, there actually is a crime if for an excluded individual to bill Medicare or Medicaid, and not only is it a crime for that, but there was a case where there was a physician who was excluded who tried to do billing, and the Louisiana Supreme Court said, no, that's enough of a connection where he could be prosecuted for a felony for having submitted those claims because he was an excluded physician. And in this case, you see here, the point to me is that the physician involved, they've been doing bad stuff for a long time, right? For 10 years or so. But the billing supervisor was part of it. The physician, he says he admits to falsifying, he admits to directing the billing supervisor, but that doesn't get the billing supervisor off the hook, does it, Robert?
No, it doesn't. And this is also a perfect example of how the physician and the billing supervisor may have thought in their heart of hearts that it was completely unfair what the government was doing, because what he was saying here was, hey, if I do these minor surgical procedures on a day right after an office visit, okay, the government doesn't want to pay me for it, because they say that all that should be bundled up into one claim.
But I should be paid.
But I should be paid. Time is money, and I'm doing the services, so there's no fraud there. I should be paid for my time. So, billing supervisor, let's bill the office visit on one day, wait a week or so, or a few days, or whatever we've done, and then bill for the other procedure so that we actually get paid for our services. So you can see, Paul, that it's real easy probably for doctors and billing supervisors to kind of talk themselves into this idea that, well, what the government's doing to them is fundamentally unfair, and therefore they ought to be paid for their work, and it's okay to do what they're doing. But the problem is that's not the rule, is it, Paul?
No, you've got, and it's an idea. It's a matter of convincing yourself, that what I did was fair and reasonable, and I should be paid. And so, well, the other part is you're saying they're not going to catch me.
Yeah, right. Because, and if they do catch me, what are they going to do? I did the services. But see, this goes back to that very beginning slide, the first slide we said, you have to turn square corners with the government. In other words, the government says, if you do these two types of procedures on consecutive days, we're only going to pay for one claim, period. Now, if you don't like our rules, go somewhere else. Don't be a participating provider. But if you're going to be a participating provider, these are the rules of the game.
And you got to follow, absolutely.
And that's why it's so important. These cases we're talking about, all the biller did was do what the doctor told them to do. And they still got involved knee deep in this conspiracy and were criminally prosecuted.
And Robert, you're the counsel to the American Medical Billing Association, and you've done tons of work with billers, and I've worked a lot with billers, and there's not a biller in the world, I don't believe, there's not a single biller in the world or someone who's involved in billing that has seen something from the physician that was wrong, and that just didn't make sense.
Yep.
And so, and dealing with that is a very difficult, is probably the most uncomfortable and difficult part for every biller. How you deal with that, and how and what they want. And, it's just, you can't always just say, well, he said it's okay. Because as we see here, the fact that he said, if you know, then you know. And you're presumed to know the rules. And the fact that the doctor told you, he told me to do it, I'm just following orders. They were decided in Nuremberg, and then, after World War II.
That's kind of an extreme example, but I agree. One of the folks listening to our presentation right now, Sharon, she says, I tell my docs, the guy who pays the bills makes the rules. That's very true, Sharon. We agree with you. If you don't want to follow that person's rules, don't sign up as a contract with them.
Yeah, that's part of the problem. I mean, they make the rules in their office, but there's a higher authority, unfortunately.
There is. All right, let's talk about these other cases, Paul. This Ohio case, this one, the owner of a medical and dental billing company, 5 years in prison because they were billing for medically unnecessary services. Very interesting. Well, obviously, they're not providing the services, but they're doing it on behalf of some provider who is, okay? And the government must have been able to show, these are all pulled from indictments and from press releases from the Department of Justice. So we don't have all the inside skinny about the particular facts. But typically in a case like this, it would be something where the biller, just from looking at the encounter forms coming across their desk, they should have known that there was something wrong here.
And I guess, the case in Kentucky is interesting because it appears, and again, we don't have all of the facts, but this was a case in which it was involved private insurance. And what needs to be understood is that in the criminal healthcare fraud statute, a private insurance is just the same as stealing from Medicare. Now, in a False Claims Act, it's different. The False Claims Act is to get money back that the government lost. But but criminally, a private insurer stands exactly the same as Medicare. And financially, although they don't have the False Claims Act, if there's a criminal case, they can come after you because contractually, you're going to owe them any amount that you have taken improperly.
Yep. Now, one of the other lines that was in the press release about the Kentucky case, they said the defendant and the partner worked out a way to evade the payment restrictions placed on certain claims by insurers. Yep. We've seen that. We've seen situations where the billers, when you actually get to talking to them, if they're being candid with you, they'll say, well, that didn't work. Let's try billing it this way. And they will mischaracterize certain types of services as CPT codes where they don't really fit that CPT code. They will engage in unbundling. They'll do all kinds of weird things to try to get the services paid. And once again, part of it is talking themselves into this idea that, well, my docs they provided the service, and it's ridiculous, these payment restrictions that have been put in place by the insurer. So we'll just bill it this way so my doc gets paid. Plus, if he doesn't get paid, chances are I don't get paid either. Okay, so you got to be really careful, guys.
A corollary to the I'm going to try and bill it this way thing is that if you have a service that doesn't fit any category, it doesn't go here, it doesn't go there. It happens not all the time, but it does happen with some frequency. And so you say, well, it looks like it looks like if you think of it this way, it would fit in that CPT code, but that's not what it is. The answer to that is you can't do that. You can't just say, well, it's pretty much like that. If it doesn't fit, if it doesn't have a code, if it doesn't have a reimbursement code, then your choices are if the doctor's doing a lot of it, that's a mistake unless he's got some kind of guidance that it's okay. It's hard to get new CPT codes. It's hard to get things covered. But you know what? You got to do what you got to do. You got to make sure that it's reimbursable, and you can't try and pigeonhole it into things that really are not, that it really doesn't fit.
That's right. That's right. Okay. All right. Let's move on here. So first of all, let's talk about what is your level of risk. You're the office manager, you're the practice administrator, or you're the billing supervisor, or maybe you're just a coder or a biller in a practice. One of the things you need to be doing is figuring out what is your level of risk in that organization.
Absolutely.
Are you a decision maker? Are you personally pressing enter and billing the federal fisc? You may think, well, I'm just a lowly biller. I've got a supervisor above me, a billing supervisor. I've got an office manager above her. And then I've got, these 16 doctors above the office manager. I'm so far down on the list, no one would ever, try to pin me for being responsible for the submission of a bad claim. Well, unfortunately, you're wrong. You're the one pushing enter. You're the one whose actions are actually debiting the federal fisc. And unfortunately, when it all goes south, everyone in the office is going to be pointing their fingers at you.
And so on the next slide, and that's absolutely critical to understand your level of risk. And I think that certainly a number of administrators are also identified as the compliance officer of that organization. And, we're not going to go into all of the duties of a compliance officer because we just finished about 25 hours of what a compliance officer might want to know about to become certified as a compliance officer. But if you are involved in that, in the world of compliance, and many office administrators are, the first thing they're going to do, once you're looking at the world of compliance, is you're going to conduct a gap analysis, right, Robert?
That's right.
Now,
what is a gap analysis, Paul?
The first thing is, it's not generally accounting principles, which I thought for the first, I don't know how many times I heard it. It's not that. It's exactly what it sounds like. It's where do you fall with respect to your obligations? What is the gap between what you do and what you should do? Identifying your weaknesses, and then you go back and correcting them. The way you identify that is through compliance plans. Now, Robert, this is really something that you do quite a bit of. We have both, as I say, taught this compliance course for people who hope to be compliance officers in small and mid-sized practices. But Robert, tell us about what it is. How do you go about conducting your gap analysis? How do you go about figuring that out?
Sure. Well, and this is so important, guys, also, because remember, if you are audited in the future, and frankly, you will be at some point, there are too many companies out there who have been hired by CMS and the privates to do these audits on their behalf. Okay. But if you're audited, you want to be able to show that you're trying to do the right thing. The government, I can tell you as a former prosecutor, the government does not expect you to be perfect, but they do expect you to try. So how do you do the gap analysis? Well, one of the ways that I would do it, if I were you, if you're a small practice, is I would pull all the claims that I billed for the last 90 days. And once I got that, I would work up a chart that shows how many times I billed each type of CPT code and who I billed them to. Okay. Because you have to kind of figure out, okay, for each one of those CPT codes that were billed and for each particular payer, what are the standards for coverage and payment that they require?
And we've talked about this. There are a million different things that you have to do, and that sometimes you can't do them all. But, the thing that the government is most focused on, really, they say it's patient harm, and the federal fisc, but I don't think that patient harm is really number one. They're looking at the money, and they're looking at if your charges are accurate and appropriate, because if they are, that goes a long way. And the only way you can do it you're totally right, Robert, is digging into claims, looking at them, understanding if all of them are done right.
That's correct. So once you figure out what the gold standard is, if you will, what the ruler is that they're looking for this particular service, whether it's an E&M code for a private versus an E&M code for Medicare, for this particular service, this is what I have to show to qualify for coverage and payment. Then you compare that to your documentation. You compare that, do you meet the coverage requirements? Are the services medically necessary? Did you actually provide the service? I know that sounds pretty fundamental, but you'd be surprised how many times we've seen where, for whatever reason, it got billed out as being performed when in fact it wasn't. Okay. Was it properly documented? Did you properly code it? And was it billed properly? We refer to all these elements as the 8 elements of a payable claim. And you can basically use that, run a claim through these 8 elements and come up with a very, very accurate idea of whether or not that particular claim qualifies for coverage and payment the way you're doing it.
Absolutely right. Absolutely. That makes the most sense. That's how you do it.
And then one of the other things to kind of keep in mind, guys, just, have you done your HIPAA high-tech security risk analysis for 2020? Did you do it in 2019? I mean, you were supposed to start doing this years ago.
Have you ever done it?
That's a real problem if you haven't. If there's a breach, the first thing that the OCR, the Office of Civil Rights, is going to ask is, where's a copy of your security risk analysis for prior years? That's the first thing they ask.
Absolutely.
All right, so we're getting low on time here, so let's kind of keep going.
On a little bit.
Yep. Okay, so Paul, this is really the issue that you raised early on. All right, office managers and billers and practice administrators, if you've got a doc who says, I don't care what you say, bill it the way I'm telling you to bill it, what do you do?
Yeah. And by the way, documenting the fact that he made you do it doesn't undo the fact that you did it.
That's right.
So
that's right.
It's a very, very difficult position, particularly if you're in a smaller practice where it's just you and the doc, but even in any practice. But if you're in a mid-sized practice, as many may be, then you don't just hold it yourself. There are mechanisms. Once you have an administrative structure, you've got to work through that and figure it out. You can't just say okay.
No. And once you put your practice on notice, if the doctor continues to say, I don't care what you're telling me, I'm going to bill it this way, the chances are they're never going to find out anyway. You can't continue to work there, can you?
My advice to them, and I know how valuable a job is, by the way. I mean, I'm not, but at some point, you just can't. There are things you can't do. Now, if the practice is larger and a little bit, closer to a mid-size, there's usually some sort of infrastructure that you can kind of work through. But if they can, and you've exhausted your remedies, this is what we were saying before, that there needs to be, as Howard calls it, a pressure valve of kind of a hotline, because you can't do it, and you're not obliged to report it. But if someone pressures you enough, you may want to. You may feel personally the need to.
Paul, let's say that you're an office manager. You've told them they're doing it wrong. They refuse to listen to you, so you decide you've got to leave. Do you have an affirmative obligation to turn around and turn them into the government?
You do not. And
okay.
Not in this country, you don't have any obligation to report something that you've seen.
That's right. But if you take any type, that the misprision of a felony statute,
right,
basically says if you have knowledge, if you take any action to conceal it,
now we're different.
Now it's different.
That's
okay.
Right.
Now you're part of the problem, not part of the cure.
Right. Now you're not just a bystander. Now, if you're a bystander and you see it, it's, there it is. If you're a bystander and you want someone to rob a bank, you're just watching it. But if they call, hey, can you start my car for me? Can you give me a lift? Well, now you're moving in. But misprison, it's only an action to conceal it. You can't do that either.
That's right. Just very quickly, one of the areas as office managers and practice administrators you got to watch out for these days. If you're doing your own credentialing in-house, there's a lot of additional risks that are out there today that didn't exist before last November.
I would say
Okay,
that's
so
one of your biggest risks beyond after billing.
be very, very careful when you're filling out these 855s. All the 855s are going to be going through a completely revamp process, and they're going to be updated over the next 3 years. CMS has admitted that, even though the law has changed, they can't possibly get all the 855s changed that quickly. So it's going to take a little while, but you got to be very careful, because if you're doing credentialing, one of the areas you got to watch out for is your affiliations, what constitutes a disclosable event, just a lot of different things. And keep in mind, everything that you say on those 855s, you may get the government or you may get the doctor to sign it ultimately. But if you think there's a problem with it, or there's a misstatement or a false statement that's made on it, what's the first thing the doctor's going to say?
Yeah, well, it's not my fault. It's there.
Not my fault. I asked the office manager to fill it out. She just told me to sign here.
Absolutely. And
so be careful, guys.
The other thing about these, about this, in line with that, not only are they changing the 855s, and they've also changed all these rules in terms of disclosure, but you also need to be aware, really pay attention to the fact that Medicare Advantage and Part D plans now, you no longer going to have you don't have 855s for them. They have their own credentialing process. So you may be dealing with more than one, probably are. Medicaid Advantage, for instance, is like some 70% of all Medicaid. And there may be more than one plan, and there may be a number of Medicare Advantage plans. So you've got their thing, but their, practices traditionally, at least in my experience, have not really paid a ton of attention to their contracts, their enrollment agreements with the private payers. Well, you may not know if it's a private payer or if it's an Advantage plan. So my only point is the 855s are one thing, the Advantage plans are another, and all of Medicaid, they're all different. So really, and if you don't credential, they really focus on that these days. False Claims Act. If you're not credentialed, you're not entitled to make a claim under that number. Then people go to the next number. They say, well, we'll bill it under another doctor's number or another provider's number. That's a big problem. Credentialing is huge, I think.
I agree. Okay, so some of the things that we've seen in recent audits we've worked on, failure to document medical necessity is always a big one. Paul, you just mentioned one that we've seen again and again and again, and that is billing for the services of a non-credentialed provider.
Unbelievable. Can't do it. Don't do it.
And we've seen those cases go administrative. We've seen them go civil. And in Tennessee recently, we saw them prosecuted criminally.
Yep.
Well, once again, who all's involved in the billing process? The docs aren't submitting their own claims. They're using their support staff to do that. So at the end of the day, it can drag in a lot of folks.
And all of those claims are going to be false claims under the False Claims Act because that person was not entitled to submit that claim in the first place. So there's no defense. There's absolutely, you can't say, well, we provided the service. It doesn't matter.
That's right. Okay, we're running out of time. Unfortunately, we got a lot more to do. This is another one, though, before we switch slides. Failure to close out an EHR entry. We've seen so many cases where our clients were audited and the progress note for the day was never closed out with the electronic signature. I mean, going back sometimes months or even a year.
Yep.
And the payer then would deny every claim saying, well, that's not a bona fide record because it's not signed. So you got to be really careful. Passive criminality, just be careful. You're filling out all these credentialing forms and all these other forms to be a participating provider. Keep in mind, you're making statements that are used by federal and private healthcare benefit programs. And a false statement to a healthcare benefit program is basis for a criminal action. Okay.
And there's also, if you have mistakes in there, or if you hold back things, maybe there's not a criminal action, but there's a lot of revocation actions these days that are
massive,
that are focused on that sort of thing.
Okay. So what do you do, office manager, practice administrator, if in fact somebody walks into your office and they say they're a federal agent and they want to ask you some questions? what do you do?
Right. Well, first of all, you ask them who they are. But yeah, there's a pretty good chance that although they're coming in there just saying, well, I'd like to answer a few questions, they're not there for your benefit. And that's just a fact, okay? And you're not going to be able to, in any explanation you give right off the bat, oh, no, try and figuring it out. They're just going to use that. They're going to write it down. So you really, and you may not know all of the facts anyway. You may say things out of context. Anything you say, if it's a lie or if they believe it's a lie, is that's a felony. You can't lie to a federal agent. So what you do, Robert, and I think we say, and I don't know, we have enough time, but get a lawyer. It's okay. It is okay to say to them, look, we really want to cooperate. I really understand, but I'm not the person to talk to you right now. I don't know what you really need. I need to get the lawyer's direction on how to deal with this. We really want to cooperate, but I really want that cooperation to be directed by the lawyer. And so I have to call them. And you can do that, and they can't stop you.
And one of the things to kind of keep in mind, and this is something that very few people even realize, when the FBI comes in, they're always going to have two agents. And you're going to notice that they're not going to record your interview.
Never.
In fact, there's actually, and I have a copy of it here, there's actually an FBI policy that says it's against their rules internally to record it. Okay. In fact, what they're supposed to do is when they leave, they're going to sit down and they're going to fill out what's known as an FBI Form 302. And then, so what they're going to do is they're going to sit down and basically write out, okay, well, here's what I said, and then here's what he said in return. It's their version of what happened. And whether or not that has any semblance of what really happened, well, good luck.
And they will use that version in the context of the lying to us, if there's other facts that are later determined to be inconsistent with what they wrote, or in an obstruction case. So the thing about that, I'm okay with them not allowing taping of interviews, because then everybody's going to want one, and then they could get altered. So I'm okay with that as a policy, but I'm not okay with them saying, we're not going to record it, but I'm going to write this down and it becomes fact. That is, to me, an offensive and wrong policy.
And it's really interesting. Keep in mind, guys, that when they come in, it's perfectly appropriate for them to say to you, oh, well, we're not investigating you, but we have questions about Mr. X. They can lie to you. You could be the subject of their investigation, the target of their investigation. They are taught to lie.
Right.
In fact, it's perfectly legal for them to lie to you.
But generally, they generally don't, as a general matter, they're not going to misdirect and say, I'm not looking at you, when in fact they are. However, they may not be looking at you today, but tomorrow they get other information where they are now looking at you. Or you may give them something that makes them look at you. So, the fact that, so even if they're telling the truth, what does that mean? What does that, you can't then later say, well, they told me that he wasn't looking at me. Just
well, Paul, I hear what you're saying, but there are some examples that have come up over the years where the conduct did, in fact, as the Supreme Court calls it, shock the conscience of the court. One where an investigator came in, lied about his identity, and introduced himself as the defendant's court-appointed attorney.
It's shocking, isn't it? And all I can say is, I don't think that happens on a routine basis.
It doesn't, but it happens. But and another one, the guy came in and said, I'm your priest.
Give me confession. Hey,
so yeah, I mean, so keep in mind, these are very, very sophisticated interrogators, and they will say something like, when they come in, if you were to say, well, I don't want to talk because I'd rather have my attorney here, the first thing they're going to say is, well, if you didn't do anything wrong, you shouldn't need an attorney.
Right. Which is why you need a script, so that you know what to do, because that is the first thing they'll say. They're very good, some of them.
So you got to be careful. You got to be careful. It's something that we really caution you about talking to these guys. And you can talk to them, not saying you can't, but just remember, their job and their ultimate goal is not something that you know.
So
And you don't know if you're really the target or a subject or a witness, or as Paul pointed out, when they may walk in, they may think you're a witness, but by the time you're through talking, you're a target.
and here's one last thing on that. I did when I was in before I was in the U.S. Attorney's Office. I did I did a lot of different things, but I probably was involved in 100 or hundreds maybe of depositions and preparing people for depositions. And so what I came to find is that people just don't really articulate what they mean the first time through. I went through countless depositions where a client or a witness said something and it sounded to me like, wait a minute, that's crazy. And I said, now wait, do you mean? And I wasn't trying to get him to say what I said, but what exactly do you mean? Are you saying this? Because that's what that sounds like. And they'd say, oh no, that's not what I'm saying. So it helps to go over what you're saying with somebody and making sure that you are really articulating the ideas that you're saying what you want to say and what you want it to mean.
Exactly. Well, boy, that didn't come out quite right, but it says questions here, believe it or not. Yeah. Something happened on the when we emailed that to the folks at MGMA.
It's not our fault, right? The doctor made us do it.
The bottom line, folks, is for the practice administrators, office managers, billers, and coders that are on the line today, you cannot sit there and think that the particular duties and responsibilities that you're handling are something that the government's going to have no interest in. If you just look at the guidance that prosecutors have been issued and the cases that are being prosecuted, you will see that the days of them going after corporations or going after merely the doctors that are involved in wrongdoing, those days are long gone. They recognize that the submission of a false claim or a misleading claim or improper conduct at all is frankly kind of a team effort. And it's rare that they would find that only the doctor had a role in engaging in that improper conduct.
Absolutely. So
our numbers, believe it or not, are on that slide, but you can't read it. There we go. That's even better. Going to the first one. Thank you. If you have questions for me or for Paul, or you want to know more about exclusion screening, or you want to know more about the anti-kickback statute or compliance, or how to do a gap analysis, or just want to complain about COVID-19, feel free to email us or give us a call, and we're more than happy to help our friends at MGMA.
Thank you, Robert. Thank you, MGMA. It was a pleasure.
Okay, thanks a lot.
Thank you all.
Bye-bye.
Thank you, Robert and Paul. I appreciate it. Thank you all for our attendees today. We had a really good group online. This concludes our webinar.